Well, good afternoon, everybody. This is Larry Gastarger. I'm the Executive Director at WIRES, and I want to welcome you to today's presentation on FERC 101. I'm really pleased to introduce the speaker we have for the presentation today. He really is a legend within the FERC community. Larry Greenfield, who's an Associate General Counsel at the Federal Energy Regulatory Commission. Larry is almost an institution unto himself. He has a career at FERC that, as I say, spans 6 decades. That doesn't mean it's been for 6 complete decades, but he did start at FERC in the 1970s, all the way up until the present day in the 20s. Larry, interesting fact about Larry, he mentioned to me when we were preparing for this presentation, he has worked for every chairman and commissioner since the beginning of the Federal Energy Regulatory Commission. So he's about as knowledgeable as anyone you can find on the commission, some of the background related to the agency, and on top of all of that, Larry is just a genuinely nice guy, and anyone who's ever dealt with him could confirm that for you. So before I go ahead and turn the presentation over to Larry, for those of you who are participating, you do have the opportunity to submit questions, and then I will pose the questions to Larry either at the appropriate time or at the end of the session. So feel free to send those questions in as you think of them throughout the presentation, and they will be forwarded to me so that I can go over them with Larry. So without any further delay, I'm going to turn it over to Larry Greenfield. Larry, take it away.
Thank you, Larry. I appreciate the kind, I should say overly kind remarks. I'm not sure I warrant them, but maybe by the end of this lecture, people will think I don't. But hopefully you'll get something out of the lecture. Hopefully at some point along the way, you'll get a peek into the black box that is the commission, who we are, what we do, and how we do it. And feel free to ask questions if you have any as we go along. I want to begin though with the cover slide, not because there's anything exciting about it, other than the note at the very bottom, which is the usual caveat whenever you have a government, and in particular a commission speaker, which is the views here are my own views. They don't necessarily represent the views of the commission, individual commissioners, or other commission staff members. What you're getting is my perspective on things, right, wrong, or somewhere in between. So with that, let's go to the next slide. Drew, please move to the next slide.
Yeah, it should be on the next slide now, Larry. We're on slide 2.
No, it doesn't seem to be moving.
Let me see here. How about that?
No such luck.
Okay. Well, rest assured, I think what the audience can see is part 1, the Federal Energy Regulatory Commission and Federal Regulation of Public Utilities slide.
Okay, on my screen it's just the cover slide, but that's okay. I can work off of, I have a separate computer set up with the slides so I can talk through them until we get the slides caught up. So for those of you who are able to get to the next slide is sort of the first part of this discussion, and up there, perfect. And the focus is going to be on the who, the what, the where, the when, and the how of the commission. You'll notice that there is no why. And the reason why there is no why is because why is actually dictated to us by Congress. Congress says, this is what we want you to do. There are reasons why Congress dictates that to us. But in the end, whether they have a reason or not, whether it's a good reason or bad reason, Congress told us, here's what we want you to do. And therefore, the why is predetermined. So with that, let's go to the next slide. You know, I bet the problem is on my screen, I am looking at 2 different things. So what I'm going to do real quickly is shut down my screen so that, because I think my one computer is talking to my other computer and I don't want that. Okay, all right, well, in any event, we should be on a slide that begins, who is FERC? And the answer is FERC is like the movie Fight Club. So for those of you who are familiar with the movie Fight Club, there's the famous line in it, what is the first rule of Fight Club? The first rule of Fight Club is you don't talk about Fight Club. What is the second rule of Fight Club? The second rule of Fight Club is really, you do not talk about Fight Club. FERC is like that because actually when people call us, invariably, they're asking one of two things. They're asking, what are we going to do? When are we going to do it? And those two things, the regulations specifically say we can't talk about. We can't tell you what we're going to do or when we're going to do it. So we are, in that sense, like Fight Club. FERC humor is kind of, lame at times, so you got to make it up where you can find it. But we are a federal agency, of course. We were created actually in 1977 by the Department of Energy Organization Act, and which took most, but not all of the authority that had been in the Federal Power Commission and passed it over to us. And much of what was not given to us was given to DOE, of course, and DOE in turn delegated a lot of that back to us. So in the end, we end up with pretty much everything that the Federal Power Commission had, with a few scattered exceptions here and there. I do want to do a check. Can you hear me at this point?
We hear you. You're good,
Perfect.
Larry.
Good. So as I say, we are a federal agency. We've been around since 1977. I have not been around quite that long, but we've been around that long. We also view ourselves as an independent agency. We're independent by statute. That is, the statute specifically says we are an independent agency. And in the words of John Donne, the poet, though we are not an island entire of ourselves. That is to say, yes, we are part of the larger government, but we are still independent. And we think of ourselves as independent in three ways. First, we are independent from improper political party influence, which is to say, by statute, no more than 3 members of the commission can be from the same political party, which definitionally means the other 2 have to be from other political parties. Usually the president's party gets the 3, the other party gets the 2. The second way we are independent is we are independent from direct presidential or congressional oversight. Now, of course, as part of the government, that's a little bit of an overstatement, perhaps. But what's important is that the decisions that we issue are not subject to oversight by the president. He does not get to dictate what we do, when we do it, how we do it. He does not get to second guess our decisions. And the same with Congress. They don't get to second guess our decisions. If someone is unhappy with what we have done, the remedy is to take us to court. So we are subject to judicial oversight in that regard, but not direct presidential or congressional oversight. And the third way we are independent is from improper private party influence, which is to say, we have what we call the ex parte regulation, which prevents people from talking to us about contested on the record or party-specific proceedings in a private setting. All those communications need to be public. Typically, they occur in written pleadings that are submitted to the commission, available to the public, the other parties in the case, anybody who is curious about what's going on. But there are no sidebar conversations between the parties and the commissioners, between the parties and staff. So in that sense, we are likewise independent. If we could go to the next slide. Okay. So the next slide is, who are the commissioners? There are 5 of them statutorily. Currently, we only have 4, and we're about to go down to 3. The quorum, by the way, requires that we have at least 3 commissioners. If we were to drop down to 2, we would not have a quorum, which raises a whole host of separate issues. But we do have 4 commissioners at the moment, and as I say, we will have 3. The Chairman Chatterjee he is appointed chairman by the president. You have to get Senate confirmation in order to be a commissioner, but the chairmanship goes to whoever the president selects. So in theory, the president could say on Monday, this commissioner is chairman. On Tuesday, the next guy is chairman. On Wednesday, the next one is chairman. On Thursday, the next one is chairman. So they literally could change daily at the president's discretion. They can't have to be commissioners first, which means they have to be Senate confirmed, but the chairmanship is at the president's discretion. Typically, the chairman is from his or her own party. Then the other commissioners, of course, Commissioner Glick, who's the Democrat, Commissioner McNamee is Republican, Commissioner Ganley, who's Republican. Commissioner McNamee, by the way, did announce his departure date. It's basically a Labor Day weekend for all intents and purposes. When I put the slides together a few weeks ago, we didn't know that date at the time. And when Drew was kind enough to say, did you want to update your slides at all? I rather blithely said, oh, no, no need to, only to realize later, yeah, the answer should have been, yes, I do. So we do know the date for his departure. Now, there are two nominees who are pending, Allison Clements, a Democrat, and Mark Kriske, a Republican. No word yet, at least that I have heard, on when they will be scheduled for committee hearings. This time of year is tough because not only is there not much left in the way of congressional sessions between now and the end of the year and the end of Congress, basically, but it's an election year, so it tends to be even shorter. But hopefully, presumably, somebody, Senator Murkowski, will probably try to schedule a hearing at some point along the way. Although, again, exactly when that happens is not entirely clear. As I noted, the commissioners have to be nominated by the president. They have to be confirmed by the Senate, and they serve staggered terms. Every year, a new commissioner comes due for either renewal, re-upping, or replacement by somebody else. And I have in the slide the dates that their various terms expire. McNamee's expired this past June, but by statute, they're actually allowed to extend their term if they choose to for some short period of time until they're replaced or until there's a definitive date, such as the end of Congress, which is coming due at the end of this year. McNamee is leaving earlier, so we don't run into that issue. And again, no more than 3 of them can be from the same party. What happens when you don't have a quorum or you don't have enough commissioners? Well, staff has a lot of delegated authority that the commission has previously granted the staff to act on the commission's behalf. And so most all of the work that we do tends to be routine, cut and dried work, uncontested cases, and those can be done by delegated authority by the staff. So the work of the commission continues in a sense no matter what. We are, as I like to say, eternal. The next slide, please. So the next slide is, how are we organized? Well, of course, there are the commissioners. Every commissioner, including the chairman, has 1 vote, which means there's always the possibility that the chairman can be outvoted. And occasionally over the years, he or she does get outvoted. Again, chairman is designated by the president. The chairman is more than just one of the 5 votes, though. He or she is also the administrative head of the agency. So the staff answers to him first, as well as to the commission, because he is the administrative leader of the commission. Staff-wise, we've asked in our budget for money to pay for approximately 1,465 employees. I don't believe we've gotten our budget yet, but we're hopeful. And by program, you can see the breakout in terms of the number of people doing electric versus gas and oil versus hydro, although I caution that those numbers are a bit misleading. It's not that we have 800 plus people doing actual electric work. There are obviously people who do the work, but then there are the people like the IT staff, the human resources staff, people like that. And those people get allocated among the different programs. So some of their what we call FTEs, full-time equivalents, or their hours are allocated to electric, and some are allocated to gas and oil, and some are allocated to hydro. So it looks like there's 800 people doing electric work, but there's not really, to be quite honest. It does give you a sense, though, of where the emphasis is, because even counting for that group of people, the HR people, the IT people, those folks, the fact is about half the agency, a little more than half, is substantively focusing on electric work, and then the other quarters are split between gas and oil and the hydro universe. By profession, it's a pretty white-collar organization. We don't actually build things. We don't run things. We don't maintain things. We're not out there fixing pipelines, building pipelines, fixing transmission towers, building transmission towers, running generators. We don't do any of that. We're a very white collar, sit at the computer kind of organization. And again, we have a lot of delegated authority that's been passed on to staff to handle the routine matters, the uncontested matters. And when there's a possibility of our running out of quorum because we don't have enough commissioners, more authority can be, and in the past has been delegated to staff in anticipation of those events. Budget, we've asked for a little over $400 million. With luck, we'll get that. We do get an annual appropriation from Congress, but by statute, we're required to recover that amount in fees and charges so that at the end of the day, at the end of the year, we are a zero impact on the budget. Congress gives us $400 and some odd dollars. We try to recover the $400 and some odd dollars. And there's a little bit of true up from one year to the next because it's never exact. Some years we end up recovering a little bit more, some a little bit less, and we true it up in the following year. Now, at one point, there was an argument made that, well, the fact that we're getting industry money means that we must be captive to the industry. And we said, no, that's not the case. And in fact, the Court of Appeals in the DC Circuit examined the issue and said, yeah, that's right. You are not captive to the industry simply because they pay the money. In fact, the money actually does not go into our pockets. It goes into the US Treasury. That money is paid into the Treasury. Congress gives us the money in the first place, and it gets paid back through fees and charges to the Treasury. We don't get the ability to, like some government agencies, some of the banking agencies, to simply say, if we need more money, we're going to charge higher fees. Rather, it's up to Congress to decide how much we're actually entitled to. And hopefully they'll give us the $404 million that we need. And with that, we can go on to the next slide. And the next slide is hopefully the organization chart. Organized a little differently than typical. I've broken it down by function. So you've got the administrative functions, the running of the agency. That's handled by the Office of the Executive Director, the Office of the Secretary, and the Office of External Affairs. They're sort of organizational groups or offices. Then most of the people are focused on the regulatory functions, the people who do the regulations, people who write the regulations, who write the orders, who review the pleadings, and they're contained in a variety of offices. Office of the General Counsel, you always have to have lawyers, thank God. Office of Energy Market Regulation, Office of Enforcement, and other things. And I would note the Office of Enforcement actually appears twice. It appears in this column, it appears in the litigation function column. And that's because when I first put this slide together a few years ago, enforcement really did have two hats. They had one division devoted to enforcement, litigation, one division devoted to sort of market monitoring. Now they've since reorganized, so that is not the case really anymore. So one of these days I will get around to correcting this chart. This is another one of those. I should have corrected this when I had the chance, but I didn't. And as I say, there are the other regulatory function offices there. And then on the far right, you've got your litigation functions, administrative law judges. We have, of course, our own law judges who conduct hearings on our behalf, to evaluate the facts, define the facts, evaluate them, make a recommendation to the commission. Bear in mind that when an administrative law judge issues his or her decision, which is known as an initial decision, that is a decision that is merely a recommendation to the commission. It's the judge saying to the commission, I've looked at things, here's what I've been able to discern, here's what you should be doing, I think. And then the commission decides, does it agree, does it disagree, and why? The Office of Administrative Litigation itself is what we sometimes call trial staff. They're the functional equivalent of a public advocate. And then the Office of Enforcement in its litigation role also does litigation. Now I should add the General Counsel's office, while it's under the regulatory functions, does have a small group of people who do litigation. They defend the commission in court, which is to say, when somebody challenges one of our decisions in court, then it is up to the solicitor's office, part of the General Counsel's office, to defend us. And we have independent litigating authority, So we do not depend on the Department of Justice to go to court on our behalf. We depend on our own lawyers to go to court on our behalf and defend us. And they're in court a fair amount because lots of people want to take us to court. Not surprising. We have important issues and money tied up in those issues. So it's not surprising we would be in court a fair amount. Next slide, please. We should be on slide number 7, the major offices. These are just descriptions of some of the offices I've alluded to before. And the next slide, slide 8, similarly picks up some description of some of those key offices. So if we can then move on to slide 9, which is the slide that says, what does FERC regulate writ large? And this is the big picture overview slide. Basically what we do is we oversee rates and services for electric transmission and electric wholesale power sales. We do that under parts 2 and 3 of the Power Act. We do something comparable, rates and services for gas pipeline transportation, and the certification of new facilities and the abandonment of existing facilities. And that's largely done under the Natural Gas Act. We also do rates and services for oil pipeline transportation, and that's under the old Interstate Commerce Act. Then we do hydroelectric dam licensing and safety under Part 1 of the Federal Power Act. That was the original part of the Federal Power Act. The Federal Power Act was first passed in 1920. It was the Federal Water Power Act, and it was hydroelectric dam focused. And that was the original purpose of the commission. It is still a key purpose of the commission. We are, by the way, in our centennial year. Federal Water Power Act was passed in 1920, and here we are in 2020. So we've been around in one form or another for 100 years. Then we do what we call certification and decertification of qualifying facilities, or QFs, which are things like cogeneration, electric generators, or renewables, small renewables, wind and hydro and the like. Solar is another example. So we oversee their certification and decertification as a qualifying facility. There's a rather involved process as to whether they qualify or not. And then we oversee the dealings between QFs, because they are, after all, generators, and the utilities who are typically buying their power. And that's done under what's called the Public Utility Regulatory Policies Act of 1978, or PURPA. And then finally, I would just add the caveat that we are a creature of statute. We do what Congress told us to do, cannot do more, cannot do less. We do what Congress wants, what Congress requires us to do. That's our mission in life. So with that, we'll move on to the next slide, which should be slide 10, drilling down electrically. So our bread and butter, because I'm an electric kind of guy, so the slides tend to be electric focused. The bread and butter is regulation of public utility transmission in interstate commerce and sales for resale in interstate commerce. Talking about the first piece, transmission in interstate commerce. We're talking about the rates, the terms and conditions of service, interstate transmission. What is interstate is always the key question. And I've broken it down into two universes, what I call the traveling electrons and the commingled electrons. The traveling electrons are basically those that cross state lines. That's almost the definition of interstate commerce. It was originally back in the 30s, 20s and 30s when Congress was grappling with the issue of whether there should be federal regulation and who should do it. So you had sales from one state to another, from Rhode Island into Massachusetts. That would be interstate commerce. The other scenario is the commingled electrons. And that scenario is what I jokingly refer to as the interstate commerce or the highway interstate commerce. If you think of the interstate highway system, you can get on a highway system at one exit, go down the road, get off at another exit, and you've been traveling in interstate commerce. The same thing essentially applies at the electric level, which is to say, you could have a transaction where the seller and the buyer are in the same state, but they're using the interconnected electric system, the interstate electric system, to move that power. So those electrons that are being moved are commingled with other electrons on this interstate highway system. And that therefore puts them in interstate commerce and subject to federal regulation. The other big thing that we regulate are the sales of electric energy at wholesale, sales for resale. And it can be a sale to any person. The buyer is kind of irrelevant as long as it is a sale for resale. As long as it is a sale to somebody who is going to resell the power, then it's pretty much definitionally going to be viewed as in interstate commerce. And we oversee those sales. Where we have jurisdiction, it tends to be exclusive. We tend not to have, the statute is written really, so we don't share our jurisdiction with the states except in rare circumstances. We can't as a practical matter. So what we have jurisdiction over is the transmission in interstate commerce, sales for resale in interstate commerce, and the facilities for the transmission or sale. Also, I should add, for those of you who are involved in border transactions, transactions with Mexico or Canada, oddly enough, for better or worse, foreign commerce is not the same as interstate commerce. So selling into or buying from Canada is not the same. Selling into or buying from Mexico is not the same as interstate commerce. That's considered to be in foreign commerce. Subject to the extent that it's regulated at all, largely subject to the Department of Energy, although some of that authority has been delegated back to the Commission by delegation orders. So we have gotten some of, but not all of it back. So we can go to the next slide, which is slide, can't even read my handwriting here. That's because I haven't moved my slide. Slide 11, which is what else do we do? And that's a lot of different things. We oversee corporate activities and transactions. So if utilities want to merge, or if they want to dispose of their FERC jurisdictional assets above a certain dollar amount, we oversee those. If they have securities issuances that are not subject to state regulation already, the statute says, the Federal Power Act says, we regulate those. And interlocking directorates, when you have officers and directors who are serving on the boards of more than one public utility or of a public utility and an electrical equipment supplier, they need permission to hold those positions, so they come to us. The accounting by public utilities, their books and records, that's subject to our regulation. Reliability never used to be subject to our regulation, but in 2005, Congress gave us authority in the wake of the big blackout in Ohio that extended elsewhere into the Northeast. But they did it in a strange sort of way. We don't actually regulate the reliability of the system per se. What we have is oversight of the development and the approval of compliance with, I should say, of what's known as mandatory reliability standards. There are standards that are created by the industry that utilities have to live up to. And we oversee their development and approval, we approve them, and we oversee compliance with the standards. But we don't actually write the standards ourselves. We don't actually administer the standards ourselves. It's really up to the industry with us looking over their shoulder. And then finally, I would add here, energy market manipulation. Up until 2005, there was no explicit prohibition of people manipulating the markets. In 2005, Congress added that. So we have the ability to deal with energy market manipulation and to chase people if we find that they have engaged in such conduct. I think we can go to the next slide.
Hey, Larry, this is Larry Gastiger. Before we leave slide 11, I had a question that somebody had submitted regarding how FERC and NERC interact, and I think that ties right into the point you were talking about on the reliability authority on slide 11.
Perfect. So how do we interact? We interact a lot, I will say that. In the broadest sort of a way, what happens is for NERC to be considered what's called the ERO, the Electric Reliability Organization, they had to come to us and ask. Congress said there would be an ERO, an Electric Reliability Organization, and anybody could have applied for that. In fact, only NERC ever applied, and everybody expected that only NERC would ever apply. And they did, and we said, yes, you qualify as the ERO, as the umbrella oversight organization for reliability. And then we also sign off on their budget. And then perhaps most importantly, since it's the ERO and its various subsidiary organizations that are responsible for coming up with the standards, we are overseeing their processes and the standards they come up with, and then we have to approve them. Once we've approved them, they become mandatory, and not only NERC, but we, FERC, can also ensure compliance. We can levy fines, NERC can levy fines, subject to our oversight of that. So it's a case of reliability in a practical sort of way is administered first by the organizations, the utilities themselves, who operate the grid, who build the grid, who operate the grid, and then by NERC and its umbrella organizations who are reliability overseers, and then FERC on top of that, keeping an eye on the whole business. So it's a very back and forth sort of relationship where we oversee what NERC is doing, NERC oversees what the industry is doing. The industry and NERC together come up with the standards, we oversee those, we approve those. Hopefully that gets the answer to the question out there.
Yeah, great, thanks.
Okay, so the next slide was, let's see here. I believe we're up to slide, I can't quite read it. It's the who is subject to FERC regulation. Public utilities. Statute draws a distinction between who is and who is not subject to regulation. And the entity that's subject to our regulation is called a public utility. Public utility is a defined term in the statute. It's anybody who owns or operates the facilities that are subject to our jurisdiction. What are the facilities that are subject to our jurisdiction in the first place? They're the facilities that are doing transmission of electric energy in interstate commerce or sales for resale of electric energy in interstate commerce. So that's what we would have jurisdiction over. And if somebody owns or operates those, that doesn't have to be both. You can be an owner or you can be an operator. You can be both. But as long as you're doing one or the other, you're a public utility. Therefore, we got authority, of course, over the traditional public utilities, the people with actual wires, the people with actual power plants. But we also pick up authority over power marketers who may have nothing more than paper assets, or the regional transmission organizations who may have nothing more than computers and office buildings and telephones, and the independent system operators who, like the RTOs, have office buildings and computers and telephones. We oversee all those because they are involved in the industry. They have assets. They operate the system in the case of the RTOs and ISOs, or they have assets like books and records or accounts that are considered to be facilities that are subject to our jurisdiction, albeit paper facilities, but facilities nonetheless. I should add that we'll talk about it a little bit later, but there are some entities that are specifically exempted from most of our regulation. Not all, but most. And I would add the caveat as well that a public utility is not the same thing as an electric utility. There are actually statutory definitions of both, and they are different. And a public utility is not the same thing as a transmitting utility. Again, there are statutory definitions, and they are not the same. You can be all three. You can be both a public utility and an electric utility and a transmitting utility because you fall within all three definitions, but you don't have to. You may only fall within one or the other or the third. But if you fall in one, you're subject to whatever the rules are that govern that one. If you fall into both groups, you're subject to the rules that are covered in both groups. And if you fall into all three, then you're subject to whatever governs all three of those groups. But they are different terms. I should mention as well, you also hear the expression, the exempt wholesale generators, or EWGs, or as they're sometimes called, EWIGs. That is probably the worst descriptive name in the entire world. I always thought that was the case because everybody assumes it means you're exempt from Federal Power Act regulation. In fact, that is absolutely not the case. What you're exempt from is Public Utility Holding Company Act regulation. If you're an EWG, the holding company that owns you can be exempt from Holding Company Act regulation, but the EWG itself can still be public utility, could still be potentially a transmitting utility, could still be potentially an electric utility. It's simply there's an exemption there for the holding company if you're only a holding company as to EWGs. The other piece of the puzzle is foreign utility companies, and it gets a little more complicated here. But again, there's relevance only for public utility holding company status. And by the way, the acronym is pronounced FOOCO, F-O-O-C-O. So for those of you who think it might be pronounced differently, you would be wrong. At least in public, you would be wrong. So I say FERC humor is a little thin. So we'll go to the next slide, which is what is not within the FERC's authority. And that's probably as important, if not more important. So what's first and foremost not within our authority is what's so-called local distribution. We oversee transmission. Then there is a separate local distribution component. And those facilities, the rates, terms, and conditions of those facilities are subject to state regulation. What is the difference between the two, you will ask? You may ask, you could ask. Well, there is no definition of what is local distribution. There is no express distinguishing local distribution from transmission. So we've come up with sort of a practical definition, which we call the 7-factor test in Order 888. And I list the 7 factors there. Broadly speaking, the more radial the facilities look, the more one-directional the power flows are, the lower the voltage, the more likely it is to be local distribution. And from time to time, there are cases that go through this and you evaluate it for a particular facility or facilities. Is it or is it not interstate transmission? Is it or is it not state regulated local distribution? But conceptually, that's the idea. You're looking at what is it, how is it used, how does it function in the system? Is it really for serving local customers as opposed to anything else? Now that's one piece of what we don't do, the local distribution piece. By the way, my own rule of thumb in that regard is I always tell people, if you see steel towers along the side of the highway, odds are it's probably going to be FERC regulated transmission facilities. If you see wooden poles running down the street, odds are it's probably going to be state regulated local distribution. Obviously, that's a rule of thumb that has probably as many exceptions as there are facilities out there, but it's still a halfway decent rule of thumb. The other big piece of the puzzle is the sales of electric energy to end users, that is to say, retail sales. The Commission, FERC, oversees resale sales. Power is sold to a customer who is going to resell that power. If it's sold to a customer who will use that power, who will be a consumer of that power, then it becomes a retail sale and is subject to state regulation. The other things we don't oversee are the generation as a general rule. We may oversee the sales from the generation, but generation itself typically not considered to be subject to our regulation because of the way the statute is written. So we don't have a say over what gets built or where it gets built or how big it's built, or is it one type of power plant versus another. Those are things that are beyond our authority. The exception to that is hydroelectric facilities, which because they're hydroelectric facilities are subject to Part 1 of the Federal Power Act and the special rules written out for them there. The other thing that we don't have jurisdiction over is transmission, the construction of transmission. What gets built, where it gets built, how big it is, the sizing of that facility. Again, not subject to our regulation. The rate recovery may be, but the construction of it is not. So nobody can tell us, you should order them as a practical matter to build a wire from point A to point B, or to build a wire of a certain size, or build this kind of power plant versus that kind of power plant. Don't certificate any coal power plants. Certificate only solar thermal conversion plants. Don't certificate any gas plants. Certificate only wind power plants. Those are questions really beyond our authority because Congress has chosen not to give us that authority. I think we can go to the next slide. What else do we not have authority over? Environmental matters as a practical matter. Again, with the exception of the hydroelectric facilities. The Federal Power Act doesn't really give us any authority over environmental issues. Hence, fights over solar and wind versus coal and gas. The environmental aspects of that, really not subject to our authority because we just don't have it. Issues of safety, we don't have it. And here's where we begin to get into some of the exemptions. The governmental exemption. If you're a governmental utility, whether an arm of the federal government or an arm of the state government, you're exempted from most of the regulation that we have for other utilities. If you're a cooperative, if you're a small cooperative in particular, but if you're a cooperative that gets money from the Rural Utilities Service of the Department of Agriculture, the RUS, used to be REA, Rural Electrification Administration, we don't oversee those either. Those are considered to be exempt. So RUS finance co-ops and smaller cooperatives tend not to be subject to our regulation. The other thing is to mention interstate versus intrastate. I keep talking about the fact that we have jurisdiction over interstate transmission, but there is such a thing as intrastate, and the most obvious examples are Hawaii. There are no wires between Hawaii and the rest of the US, so everything in Hawaii is intrastate, not subject to our regulation. And Alaska is in the same boat. There are no connections between Alaska and the rest of the US, so again, we don't have any jurisdiction. Texas is in much the same position. What's within the Electric Reliability Council of Texas is largely considered to be electrically isolated, like Hawaii or Alaska. Technically, it's not, in fact, but for various legal reasons, it's treated that way. And so the ERCOT portion of Texas is not subject to FERC regulation, or most FERC regulation as a general rule. And Puerto Rico and the US Virgin Islands and the other territories for the same reason. They're not electrically connected. Every once in a while, somebody talks about building a submarine cable between Puerto Rico and the Virgin Islands, which would make for interstate commerce and would provide for FERC regulation. But nobody's done it yet, and given financial circumstances at the moment, probably will be a number of years before that ever happens. So until then, not subject to our regulation. The next bullet point I actually mentioned earlier, which is to say, if you have a seller and a buyer in the same state, but they're taking advantage of the interstate grid to move the power from one to the other, that's going to be subject to our regulation. That would be interstate commerce. And the other thought to bear in mind, finally, is that the focus of the Federal Power Act is on the seller, the person providing the service, providing the power, providing the transmission. It's the seller. It's not the buyer. Did the seller charge a just and reasonable rate? Did the seller behave properly? That's what we're looking at. We don't look at whether the buyer was smart or dumb in making their purchase or taking service. Should the buyer have gone to an alternative seller? Maybe, maybe not. But it's not for us to second guess a seller's decision to buy. It's for us to oversee what the seller is. I'm sorry. Is it for us to oversee what the purchaser has done? No. Is it for us to oversee what the seller has done? Yes. We want to make sure the seller is treating people appropriately. The intelligence of the buyer and choosing what the buyer wants to do, that is for the state to worry about. Let's go to the next slide.
Hey, Larry, before you move on, a question on this slide that I received was, somebody was curious as to whether there's any way for a co-op to opt in to FERC jurisdiction, or essentially sort of voluntarily subject itself to FERC jurisdiction.
There is a way to do that. And there are co-ops that are in fact subject to our regulation. First off, you got to have no RUS debt. So you pay off your RUS debt. That's the first thing. Then the second thing is you need to be big enough so that you fall within the universe that is not exempt under the statute. If you don't do that, if you're still subject to RUS financing, you're still taking money from RUS, or if you're sufficiently small, you can't really volunteer to become a FERC regulated entity. You either fall within the definition or you don't. You can't say, even though I'm outside of the definition, I want to be in that universe. There is not a lot of case law on that, but there are cases out there that say you can't volunteer for FERC regulation in this kind of a scenario. So, so there are ways to get there, and there are co-ops that have gotten there, but you have to do some things. You have to get rid of your rust debt, and you have to be big enough that you would qualify for FERC regulation, that you would qualify not to be exempt or no longer exempt. And then you could be treated like everybody else.
Great, thanks.
Turning to the next slide. So we're going to talk a little bit about some of the other aspects of FERC regulation. Hydro Authority. Hydro Authority is focused on hydroelectric facilities on navigable waterways, which includes tidal facilities. And the definition of navigable waterway is pretty broad. It can be a pretty minimal stream and still be considered a navigable waterway. We license the construction of hydroelectric dams. We relicense them because the dams tend to run for a very long time. And these are dams used for power production. We don't license every dam in the country, but when you have a dam that's associated with power production, we license them, we relicense them, and we oversee their operations. So we do dam safety inspections, we do environmental monitoring, because the job is to make sure that, we used to say our job is to make sure we don't have another Johnstown flood. But of course, we've had some issues in Michigan, as you probably are all aware. But that was a dam that was no longer licensed. They lost their license because they didn't comply with our requirements. And that meant they defaulted back to state regulation. And that's kind of where the problems began, at least from what I can tell from reading the trade press. But if you're a power producing dam, then you're probably going to be subject to FERC regulation. And there's a fair amount of FERC regulation when it comes to power dams. The next slide we can go to is, what about gas? And our authority under the Gas Act is pretty similar to what it is under the Power Act, because the Gas Act was largely modeled on the Federal Power Act. It was passed in 1938. The Power Act was passed in 1935. So the original idea had been to do the two of them together, but that proved to not work out. So the Gas Act came along a few years later and is modeled on the Power Act. So again, we're talking about transportation of gas in interstate commerce in the same way we do transportation of electricity in interstate commerce. And you've got not only the pipelines, but it covers storage facilities, LNG facilities, and the focus is, again, making sure rates are just and reasonable and not unduly discriminatory. We'll talk about that more in just a bit. We also certificate construction, which we don't do on the electric side, but in the Gas Act, they put in the authority for the commission to certificate construction and operation of not only the pipelines, but storage and LNG. And we make what's called a public convenience and necessity filing, which many of you may be familiar with. States often have these kinds of filings. And if you want to abandon facilities, you have to come to get our permission too. And then under the what's called the Natural Gas Policy Act, the NGPA, we also have some authority to regulate intrastate gas pipelines if sometimes they do some things in interstate commerce, even though they're otherwise considered to be intrastate. Oil pipelines. Oil pipelines are a different issue because there's a whole different regulatory structure for oil under the Interstate Commerce Act. And that's not a traditional cost of service kind of regulatory scheme. It's an indexing kind of scheme where every so often we establish a rate, and then over time that gets changed or revised or down, reduced every year based on certain changes in certain indices. And then I think it's every 5 years we do another analysis and reset the starting point. So it's a very different kind of regulation. And the focus is making sure that not so much that rates are themselves J&R definitionally, but you want to make sure that all the shippers have equal access to pipeline capacity. And that is the only part of the oil industry we really regulate is the oil pipelines themselves. Move oil by truck or train or whatever, that's not subject to our regulation. It's just oil pipelines. It is a pretty light-handed regulation compared to what we do for electric, compared to what we do for gas, compared to what we do for hydroelectric. Okay. Next slide would be, where is FERC? Well, we're in Washington, downtown, not too far from the Capitol, right around the corner from the CNN building. We have some satellite offices in various places. Some of them have engineers who do hydroelectric dam inspections. Some of them have people who work closely with the RTOs, ISOs. And our reliability folks used to have a satellite office. I confess, I don't know if we actually still have it. There was discussion of getting rid of the satellite office in Hagerstown, Maryland, which is out, an hour or so west of the city, for those of you who are familiar with the Washington area. So we do have some satellite offices, but far and away, the vast majority of the employees are located in Washington. Of course, everybody's now working from home. You risk life and limb to go into an office these days. So everybody's at home with computers, as is everybody across the country in many instances. Next slide, please. So how do we do our business? We meet, the commission that is, meets formally, publicly, the third Thursday of every month, with the exception of August, when we don't have any formal commission meetings. The meetings are webcast, and I think they're televised. They used to be televised on a C-SPAN channel. I'm not sure if they still do that, but they are certainly webcast. And they begin roughly around 10 o'clock each morning. You can go onto our website and dial in and watch them. It's super exciting, is all I can say. Commission also has the ability to meet in what they call closed meetings if they want to talk about litigation matters or enforcement matters, but that's not a common occurrence. More relevant, they can do what's called vote notationally, which is to say, you don't have to have a formal commission meeting to vote. You can vote on what, at least in the old days, was a paper ballot. Now it's an electronic ballot. So that you can vote on things between commission meetings, or in August, vote on them in a month when there are no commission meetings. And so you can vote not only at the meeting, but you can vote on matters outside the meetings. And every day we end up issuing orders of one sort or another, some more important, some less important, many of them done by notational voting, by this formerly paper but now electronic voting system. And of course, there's the delegated authority that staff has. That's the vast majority of the cases, because the vast majority of the cases are pretty straightforward, uncontested cases. Our decision-making is, we generally focus on two kinds of things. We do our case-specific contested proceedings, litigation of a rate case by company A seeking to charge more to its customers, or as an example, or generic decisions, rulemakings intended to change the regulations codified in the Code of Federal Regulations. We do that several times a year in various aspects. We just did one recently on PURPA, on the so-called qualifying facilities, or QFs. We did that back in July. So we did that one. But we do those two different kinds of ways. What's important about those is you participate in those proceedings two different ways. If it's a rulemaking proceeding, there are no parties per se. You participate just by filing comments. And the ex parte regulations do not apply in those contexts. There's an express carve out for rulemaking proceedings. So parties can talk to the commissioners, can talk to staff in those scenarios. In the case specific adjudicatory proceedings, it's different. You have to become a party. And I'll talk about that in just a second. And you have to abide by the ex parte regulation, the no private communications regulation. The reason why intervention as a party is important is if you ever want to go to court, working backwards, if you lose and you want to go to court, you have to have sought rehearing or reconsideration of the commission's decision. And the only people allowed to seek reconsideration or rehearing, as it's known, are people who are parties to the case already. So you need to be a party up front. So if you lose at the commission, you can ask for the commission to grant rehearing. If you lose again, you can then take the commission to court. So most people who want to get involved in commission work, most companies, most parties, do become a formal party. That is, they file whatever pleadings they're going to file, and they seek to intervene. They seek to become a party because that entitles them to seek rehearing of a decision to go to court then in turn. So becoming a party is important in the case-specific adjudicatory process. And again, though, the ex parte rule does apply. No private communications allowed. Everything has to be public above board. With that, we can go to the next slide, which is part 2, the rate revision process. Give you a quick overview of rate making, because that's in many ways what most of our cases involve, at least litigated cases. So, so how does the commission do what it's supposed to be doing, which is protecting consumers? And we do it in 3 ways. And it's the same for both the Gas Act and the Power Act. We review rate filings with a utility or a gas company. Gas pipeline wants to change its rates, typically wanting to increase, but sometimes decrease rates. They have to make a filing with us. We get to look at it that way. Alternatively, people can seek or can file a complaint. Customer, a competitor, a state commissioner, public advocate, private citizen, anybody can file a complaint with the commission, which the commission would look at. And likewise, the commission has independent authority on its own without being prompted by a utility or a pipeline company, without being prompted by a customer or a competitor, to look at somebody's rates, to look at their terms and conditions and say, these things don't look right. We need to investigate. We can go to the next slide, which I believe is slide 24. The standard that we use is what's called a just and reasonable standard. That is, the statute says whether it's the Gas Act or the Power Act, whether it's on complaint or on the filing of a utility or gas pipeline company, the rate has to be just and reasonable. The shorthand we use is J and R, and I should say it has to be not unduly, having double negatives, not unduly discriminatory or preferential. Put differently, it cannot be unjust and unreasonable, and it cannot be unduly discriminatory or unduly preferential. What does all that mean? Basically, it means if you're just and reasonable and you're looking at a cost-based kind of rate, is it cost supported? Do the cost of providing the service justify the rate? If we're talking in a market scenario, the question is, does the seller, the provider of service, do they have market power such that they can charge a rate higher than what the market will bear? So you're looking at, is it cost justified, in which case we do a cost of service analysis, or is it market justified, in which case we look at market power? But what about the other piece of the puzzle, the not unduly discriminatory or preferential rate? The focus here is on comparisons. The focus here is on what do similarly situated customers face? Are similarly situated customers being treated similarly? They are, after all, similarly situated. Shouldn't they be treated similarly? If there's differences that are not justified, then it may be unduly discriminatory. That is, discrimination without a good justification is undue discrimination. Discrimination, differences with a justification, I suppose you could say, is due discrimination. That is to say, differences are not themselves inherently inappropriate. It depends. It depends on the justification, the reasons, the support, the basis for the differences. If there is support, if there is a basis, if there is justification for treating customers differently, then it's fine to treat them differently. It's fine to have different terms and conditions, fine to have a different rate. But if there are no differences or minimal differences, if they are similarly situated, they are to be treated similarly, same rate, the same terms and conditions. And so the fight is often how similarly situated the customers are. And I should add, again, the same standard applies whether you're talking Gas Act or Power Act, whether you're talking a complaint situation or a utility filing situation or a gas pipeline filing situation. The standard is the same. Things have to be, rates have to be, terms and conditions have to be just and reasonable, not unduly discriminatory or preferential. After a while, you get to recite these expressions in your head at night when you're dreaming. Take another minute or two just to finish the last few slides. This is my picture of the commission building. The commission building is, well, it's hard to describe. It's about the middle of the picture on the left-hand side, the long, thin building that pops off from the railroad tracks. That's FERC. So it's seen from above. There's a 3-act process. Like every good play, there's a 3 acts. Boy gets girl, boy loses girl, boy gets girl back, the end. In our process, there's a hearing order and a hearing, and then a final decision. So what happens is you have a hearing order. Somebody files something, whether it's a rate case, whether it's a complaint, they file something. With our preference as an organization is, if we have a sufficient record, if we have sufficient evidence, we will prefer to render a decision. Here's the answer, we're done. That's if we have a sufficient record. If we have an insufficient record, there are a number of options we can pursue to get a better record, to get more evidence. We can have a paper hearing, which is to say briefing. Most typically, that's going to be used when the issue is more of a policy issue or a legal issue. We'd ask the parties to provide briefs. We can go with a full trial type evidentiary hearing, the whole 9 yards, discovery, witnesses, cross-examination, more briefing, decision by the judge, the whole 9 yards. And that's more typically used when we've got traditional fact gathering that we're interested in. We need actual hard facts. It's not just an issue of policy, or maybe not even at all an issue of policy, but an issue of fact. And that's when we turn them over to the judges. We can also order a technical conference. And that often is the situation when there's just a discrete issue, some particular issue that's pretty sharply defined. And we just need to understand the particulars. We want to ask questions so that we better understand what's going on. Then we would set up a technical conference, get what we need, and then go ahead and issue a decision. We can also refer the case to our so-called dispute resolution service, people who help mediate or arbitrate disputes between parties because, well, the case should settle. Go off and settle, people. And the DRS, the Dispute Resolution Service, is there to help out. And we also have more formal alternative dispute resolution, such as mini trials, binding arbitration, and the like, if we need to go that route. And you can use some combination of things. You could have a technical conference followed by a hearing, or a paper hearing followed by a trial type evidentiary hearing, depending on what you discover as you go along. So when you get to hearing, assuming we go to a trial type evidentiary hearing, it's just like what you've seen in other contexts. Before a judge, there's discovery, there's submission of evidence, there's testimony, there's cross-examination. And at the end of the day, what will happen to the case is either at some point along the way, the parties will come to settlement, or there will be a decision, an initial decision, a recommended decision by the judge. Ultimately, it will come back to the commission, which takes us to the next slide, 28. If it's a settlement, there's a whole process for settlements. What we're looking for ideally is an uncontested settlement where everybody is happy. And we look at it under a fair and reasonable standard, which is a little bit easier to meet than the traditional just and reasonable standard. If it's contested settlement, though, then it has to go to the full commission for ultimate decision. Either way, though, there's going to be some sort of commission order. Easier if it's uncontested, more involved if it is contested. Alternatively, if people are still fighting, well, you've litigated it, the judge will make a decision. That decision is a recommendation to the commission. Parties can challenge it before the commission and say to the commission, affirm the judge, overturn the judge, and the commission will decide. And that is the end of the case, other than people have the opportunity to seek rehearing. But again, you need to file, you need to be an intervener. You need to have filed to intervene in order to be a party, in order to seek rehearing, in order to then go to court. And that, talking very fast, is how we get to the end of the slides. Thank you very much. And I appreciate WIRES giving me this opportunity to talk to you all. And hopefully there's something there that you've learned. And if I confused you, I apologize. I'm sure that I probably confused some people. And I had some other slides which are just a little more detail on things, but you're more than welcome to read those at your leisure. They're all pretty straightforward. My slides tend to be rather text dense to start with, a lot fewer pictures than most people. I like words, less so pictures, except of course for the Fight Club poster. But with that, again, thank you very much.
Well, great. Thanks, Larry. Really appreciate that. That was a really interesting overview. I do have a few questions that have come in, and I'd like to run them by you if
Sure.
you have time. I think we have blocked out until 3:30 for this.
Yep, sure.
And I just wanted to follow up on your comment about the appendices you have on the presentation, which deal with some of the more details related to 205s and 206 filings. And I think that information would be helpful for some of our members. And I know this is a presentation which, probably you could spend even a day or two if you really pulled it out and teased all of the detail out. And I appreciate your putting it into a more concise format for us for this type of an overview. I have a couple of the questions that came in. Some break down in terms of substantive issues and a couple are procedural. So let me ask you the substantive ones first.
Sure.
The first one I got was on the Commission's authority over transmission. And it says, if FERC cannot direct specific transmission, then how does FERC regulate the planning provisions that RTOs and ISOs use to direct construction of specific transmission?
Well, it's not so much that we can't direct transmission. We can tell people to provide particular services. What we can't do is tell people to build particular lines. Now, that being said, this gets into a little more of the details. There are sometimes ways to do indirectly what normally you wouldn't be expected to do. That is to say, there are scenarios where a failure to build some facilities may be considered unduly discriminatory, for example. And we can, in a backhanded sort of way, get people to do things. So we do have some ability to get construction going. So for example, in the open access transmission tariff that we adopted in Order 888, we said that if somebody, this is speaking rather broadly, but we said essentially that if somebody is unable to provide service, then they need to look into building something to be able to provide service. So we do have that there. That's a rarely invoked provision because usually utilities are pretty good about staying on top of customer demand. And if they see there's a demand for particular service over particular lines that maybe are underbuilt and need to be improved or the capacity increased, generally utilities are pretty good about saying, there's an opportunity here to enhance the system by building more lines or building higher capacity lines, reconductoring, doing something, improving, upping the capacity of a substation. So it's a rare circumstance where you hit, at least in my experience, you hit situations that utilities are just recalcitrant and refuse to do anything. It may not be what somebody else thinks is ideal, but usually they're pretty good about doing something. And as I say, we can, in a backhanded way, sort of get them to do things. The industry is pretty good about paying attention to that kind of stuff. And but yeah, it is an imperfect world when it comes to how do you mesh that with the planning requirements of Order 1000 or elsewhere. If you can't tell people you must build this wire, you must build that wire, you must put in this substation or that substation, it is not always as easy to make it all fit neatly. The best I can do is say it's an imperfect world. We do the best we can under the statute, and usually things work out, maybe not perfectly, but reasonably well.
Thanks. And the next one I have also kind of focuses on the FERC RTO relationship, and this one also involves a matter that is of real interest to a lot of the members in wires, which is Order 1000. And the question is, how does FERC ensure that Order 1000 is being properly implemented by the various RTOs?
Well, that's an interesting question, and there's, I think, several answers to it. One is we do audits of utilities from time to time, not necessarily focused on this issue specifically, but nothing stops us from looking into that question, and we could if we wanted to. But I would say and we have the Office of Enforcement. If we think there's an activity that's inappropriate market manipulation, the Office of Enforcement can look into it and see what's going on there. If somebody isn't abiding by Order 1000 in a way that amounts to market manipulation. But in practice, the way things tend to work is the industry has lots and lots of squeaky wheels. That is to say, there are people who are not afraid to file paper with us. Customers, competitors, state public advocates, state attorney generals, NGOs, non-governmental organizations. If they think that somebody isn't abiding by the rules, they are not afraid to file pleadings with us saying exactly that. And then we institute proceedings to look into it and see what's what. And so we depend a lot on, call it citizen monitoring, for lack of a better phrase, or participant monitoring, for lack of a better phrase. And people come to us, and that's a lot of our businesses being responsive to various complaints and objections. So-and-so utility is not abiding by the rules. So-and-so utility is not living up to its obligations under Order 1000 or Order 888 or Order 890 or any of the other orders. And in those situations, we look into it, and sometimes we find there's merit to it, and sometimes we find there's not. But it's a very squeaky wheel driven world, simply because there's lots of squeaky wheels, and we have no doubt that there are people willing to take the time and effort to file those complaints, to file those objections, so that we can look into them. And that's a lot of what's involved in the process.
Well, thanks. And now the next one deals with something I know you're very familiar with, and I think FERC is really focused on now. There was a recent court decision that came out relating to the Commission's authority with respect to the timing on rehearings. Is there anything you can talk about with respect to the recent court decision and consistent with Fight Club rules 1 and 2, how that affects the rehearing procedures that the Commission is going to be using going forward?
Well, I can comment a little bit on that. We are still trying to work through some of the details of it because, as you can imagine, there's a lot of internal process, a lot of internal organizational structure built around how do we move paper from the moment it walks into the Commission to the moment an order goes out on the other end. And it can get surprisingly complex within the building in terms of how we monitor it, in terms of how we track it, in terms of how we create it. So there's been a lot of discussion still ongoing about that. From the external point of view, you've probably seen already, there have been orders of a couple of different types that have gone out. Well, almost immediately, we recognized, in fact, that under the court's interpretation, there was not a lot of room for just saying to the court, never mind, we're going to ignore you. We're not an agency that does that. Some agencies I know, I've heard, do that kind of thing. Says, who cares what the court says? We are not one of those agencies. So almost immediately we thought, well, okay, if the court is telling us that you have to do something within 30 days, then we need to start doing this something within 30 days. And the court said, essentially, you can no longer use tolling orders, orders granting the hearing for purpose of further consideration. Those are off the table. We thought, okay, we can't do that. And which means that our choice, at least initially, is within the 30-day period, can we issue an order on the merits? And if we can't, then what happens? And sometimes we can, but if we can't, then what happens? And what happens is rehearing is deemed denied by operation of law. So if 30 days goes by and there is no merits order, no merits decision, then rehearing has been denied and parties are free to go to court. They have, if I remember right, up to 60 days after that decision to go to court. They don't have to go to court on day one, but up to 60 days thereafter. The Commission, though, under the statutes, both the Power Act and the Gas Act, is not barred from issuing more orders at that point, because the statutes do allow the Commission to issue orders up until the point in time where the record is, I believe the phrase is, certified to the court. And that usually happens, it can happen at varying times. But my understanding is under the federal rules of appellate procedure, that can happen as early as 40 days after the appeal. So you've got whatever time is allowed for the appeal. So if the appeal comes in on day 31, there's the day of the original order, denied by operation of law on day 30, an appeal comes in on day 31. At a minimum, we have, I think, the 40 days to issue a second order in the case. So 30 plus 40 is 70 days. So from the day the rehearing comes in, it's about 70 days for us to do something. Now, in fact, sometimes that's longer because people don't seek an appeal immediately. And we have the ability also to ask the court to give us more time. I don't know if we've done that yet or not, to be quite honest. I don't follow every case correctly, but we certainly have that ability to ask for a little more time before we certify the record to the court. So we're certainly cognizant that the court said in en banc that you can't toll anymore like you used to. But bear in mind, it doesn't mean that there's no ability to issue order. It does mean that 30 days rehearing is denied, assuming we can't issue an order in the 30-day point. But there's the possibility of a second order. So some of the orders we've issued at the 30-day point do say, I forget the exact words and what I've seen, but they do say that basically, my interpretation, basically, keep your eyes open, there will be a further order in this case. So that's telling the parties really, yeah, we're going to be issuing something. We're not saying exactly when, because we can't do that, but keep your eyes open. Subject to the statutory parameters, there will be a second order in the case at some point in the not too distant future. Is it on day 48 or day 71 or day whatever? It just depends on the individual case. But we know we have the ability until the record is certified to issue that second/rehearing order, assuming we didn't do it within the 30-day period. And then sometimes we just say within the 30-day period, we're not going to issue anything else. And there would be a notice saying, just rehearing denied by operation of law, period, we're done. And that's a way of signaling that, in fact, at least to my reading of it, that we're not going to be issuing a second order. In theory, we could, but it's our way of signaling it's unlikely that we're going to be issuing that order. So if you see a tolling order, I'll call it that for lack of a better phrase, a newfangled tolling order that just says rehearing denied by operation of law, then odds are we're probably not going to be issuing any more paper. If you see it refer to the possibility of other orders down the road, then odds are we're probably going to be issuing more paper. But we're still sort of working through the details on all of that. We're just going to have to see how it works out. As I say, there are lots of things that go on that relate to our internal processes for moving paper because we're a large organization, albeit only 1,400 and so on people, but still that's a pretty good sized organization. And we have to have processes in place to ensure that we do things in an appropriate way, in an appropriate time frame. And so we're working through those details. But my sense from what I have seen the commission issue so far is sometimes we're just going to deny rehearing by operation of law and be done with it. Sometimes we will actually issue a merits order within the 30 days. And sometimes, we'll deny rehearing by operation of law, but there will be a second, or we think, or we anticipate there will be a second order coming down the road at some point in the not too distant future. I hope that wasn't too confusing.
Well, it is a little bit confusing, I think, for people in both inside the building and outside as this process moves forward. But I guess what I was specifically thinking about the order where it indicates that the commission will issue a further order, and it doesn't indicate exactly how that process plays out. But what I think I'm hearing you say is in those situations, you have up until the time that the record is actually filed with the Court of Appeals, and then FERC actually loses jurisdiction at that point. But right. up until that point, something else will be coming, whether it's just a short, order indicating that no further action is going to be taken, or it could be a full-blown further order on the case, right?
Yeah, you've I think more concisely captured it than I did. when we issue one of those orders that says, look, keep your eyes open for a further order, odds are there probably is going to be a further order done within the time frame spelled out by the statute, which is up till the moment when the record goes to the court. And that date's a little bit uncertain because it's tied to when the appeal is actually filed. It's tied to what the court provides in terms of the date for the submission of the record. But there will be a second order, is at least the implication of those newfangled tolling orders in that scenario.
Yeah, I guess I would just only on closing that question out is clearly to the extent that there's any further guidance or insight the commission can offer into its own internal processes or thinking on it. I think for those of us on the outside, that would be extremely beneficial and helpful for us to understand what's going on. So I just would add that little plug to you guys on the inside.
Yeah, there has been discussion of doing something like that to try to put together some discussion. I don't know if it's necessarily going to be a document or a presentation at a commission meeting or guidance on the website, putting together something to provide the world a better understanding of where we're ending up. But I'm not sure that anybody has yet finally resolved that question one way or the other. I wouldn't be surprised if there was one coming out at some point. I wouldn't necessarily be surprised if there wasn't.
Yep.
But there's been talk about doing something. But we talk about a lot of things at the commission.
But I have just one or two more quick questions for you. One was, can you talk a little bit about how the commission decides what it puts on the open meeting agenda versus what it handles notationally, or how that process is resolved?
Yeah, there's less science and more art to that process. One of the big drivers of that is it something where the chairman or commissioners want to put something on the agenda? There's something of sufficient significance or moment that they want to put it on the agenda and talk about it. So that's one of the drivers in the process. Another driver in the process is sheer timing. It may well be that we need to issue something in a certain time frame and it coincides with commission meeting, in which case great, or it doesn't coincide with a commission meeting, in which case not so great. So the timing of that, when we need to act, is important as to whether we do one versus the other. Another driver is how important it is more generally. If we're talking a major rulemaking, the general preference is to try to put that on an agenda as opposed to not. Although, again, that's not 100% rule either. If it's a more typical, are we setting this case for hearing or not, or it's a petition for declaratory order that is some issue between two parties, but no great moment to anybody else in the world, then it doesn't really matter that much one way or the other. So those are some of the concerns, but the timing of it has a lot to do with it. Just when do we have to get the order to the commissioners? When does the order have to issue? Just the mechanics internally of that, and when the order has to issue can often drive a decision, whether it's on one versus the other. And as I say, it is much more art than science. And
then one just last follow-up question, general one that somebody posed, which is for someone who's interested in following what's going on at FERC, what would you recommend that they do to keep abreast of what's going on at the commission? While I am not on social media, I confess, the commission itself has social media, presence through Twitter and all the Facebook and all the social media out there that I don't belong to. So you can go sign up on all that social media. You can also look at the website, truly every day if you wanted to, because every day we post all the orders and notices that we've issued that day. That can be rather time consuming. So going on the social media is a good way to do it. And frankly, just subscribing to some of the trade press, because the trade press is usually pretty good about picking up on things immediately or within just a day or two of something that's been issued. So if you read the trade press, every morning or every evening, whenever you do it, it's a good way to kind of keep your hand in a little bit.
But I would say subscribing to the social media feeds that we have is probably the place to start.
Well, thanks, Larry. You say you're not a person who follows social media. I can tell you that if you were someone who follows social media, and if you had seen some of the response we got back to our social media promotion of this presentation, and you in particular, it was quite impressive. Like I said to someone earlier, your mother would be proud if she could see what everyone was saying about you as we were promoting this on social media. And I think for people who have been listening and participating in this conference call, they'll understand why you got all the accolades you did get when we were promoting it. Thank you very much for doing this. I really appreciate it. It was a very interesting presentation. And I said to people when we were promoting it that even for people who are pretty seasoned FERC practitioners, you can always learn something new or interesting or different about FERC through something like this. So thank you once again, and I really appreciate your taking the time to share this with us today, Larry.
Well, you're certainly welcome. Thank you for the opportunity to do this, and hopefully I didn't disappoint, but you never know, but hopefully I didn't.
Well, not at all. And this brings the session to a conclusion. I want to thank everyone else who participated in it. And thank you again, Larry. And we look forward to doing another one of these on a different topic coming up later this month. So for WIRES members, stay tuned and we'll provide more information on the next session for mid-September. And with that, we're going to bring it to a close. And thank you all very much.
All right, thank you.